Hi, my name is Rita Amarichinda and I welcome you to Hashtag IP series. If you're a new listener, thank you so much for listening to my podcast and also taking out the time to listen to this episode. If you're a returning listener, thank you as well. I really do appreciate. So what we do here is talk about recent intellectual property cases and development globally, which could take the form of copyright, trademark, patent, industrial design, trade secret, geographical indication, and plant variety. So on today's episode, I will be discussing if it's possible whether or not Christian/gospel music can be copyrighted. Do they really enjoy copyright protection? Let's get right into it. So, do Christian or gospel song enjoy copyright protection? The answer is yes. And that is in line with Section 1 of the Nigerian Copyright Act, which lists musical works as works eligible for copyright protection. We know that copyright enjoys automatic protection from the moment it was created. Even if it's like the song was created for God or to be used in a religious gathering, the work is already copyrighted. Whether or not it's registered, it's already enjoys copyright. So I'm just going to break it down for everyone. And as tradition, here is a summary. So today's case is about RCCG National Praise Team against Mr. Akande Akinbode Emmanuel over the song I Will Never Be Ungrateful. Now, Mr. Akande is suing the RCCG National Praise Team for copyright infringement and reproduction of his song I Will Never Be Ungrateful. So, sometime in 2016, Mr. Akande's boss attended an event where he heard the song I Will Never Be Ungrateful. And when he went to make inquiries, he was told that the song was by RCCG National Praise Team. He disagreed and was like, he knows who the songs originally belongs to, and it wasn't the RCCG National Team. Now, to confirm this, he went home and listened to the song by Akande, and surprise, it turned out to be the song that the artist recorded sometime in 2005. So do the math, 2016 and 2005. So 11 years apart. See how long it took a copyright owner and an IP owner to discover that his song was being infringed and used without his permission. One of the foundation of copyright is that any work created and put in a fixed medium is automatically protected from the moment that work has been created. However, registering it and depositing a copy to the Copyright Office will give you an upper hand in the event of a dispute. For instance, in the United States, it's been held that if you've not deposited a copy or registered your copyright in your work, you cannot sue for copyright infringement. But that's different in Nigeria, where Section 10 states that copyright shall vest with the initial author, and in this case, that is Akande. And another benefit for registering your copyright is that it serves as proof of documentation. So when a dispute arises and they're trying to determine who actually owns the work, you can show that to the court, and So after listening to the song and confirming that it truly belonged to Akande, Mr. Akande's boss will now go ahead to register the album at the Nigerian Copyright Commission. So I put a caveat in my tune and I said, "Dear creatives and innovators, do not wait until your intellectual property has been infringed upon before you go ahead to register it, especially if it's an IP such as a trademark, a patent, or a design right. Else you might just be too late to do anything about you. Unlike copyright, where you get automatic protection, the other forms of IP, patent, trademark, industrial design, you have to register it because it gives you an unlimited protection and legal backing. So no one can mess with you when your work has been registered. So after making the application at the Copyright Commission, he would go ahead to brief a lawyer to do a demand letter and also attached a jacket of the CD showing that Mr. Akande's information was actually on the CD. So if they really wanted to use the song, or say, okay, we couldn't get access or reach out to Mr. Akande, his information was actually on the CD. And we know that when it comes to intellectual property dispute, it's advisable that you always contact and brief your IP lawyer so that you are properly guided as to whether or not a dispute actually arose and whether whether the person is the original author, whether or not. I think you're going to look at a lot of things. So you're looking at if what was infringed on was substantial or whole. So there are several factors you'll be looking at, which is why it's advisable that you have an IP lawyer on your retainer. So moving on, the letter was dispatched and it got to the table of the director of music, Pastor Kunle Ajayi, who will now reach out to Mr. Akande and request that they meet and talk. So Akande goes to see Pastor Ajayi without even letting his lawyer that did the demand letter know. So he attended the meeting alone, and that was where Pastor Ajayi told him, it's better you drop this copyright infringement claim. And then I said, I'm going to make you my family friend. And to show you how serious I am in making you my family friend, I am going to let you perform at the Holy Ghost service. I mean, it felt like a dream come true, Things creatives should know. As a copyright owner, you alone have the exclusive rights to do whatever you want with your creation. And Section 6, Sub 1, Paragraph 3 of the Nigerian Copyright Act lists the right to perform your work in public as one of those exclusive rights that you get to enjoy alone, save for when you give someone the permission to, perform your work in public. See also Section 26, which talks about neighboring rights, aka performers' rights, aka related right, copyright related right. That's how it's called. I'll do like an explanation about that later. To me, as far as I was concerned, the offer made by Pastor Ajayi to Akande was not good enough, but oh well, it's one of those things that happen. Now it turns out Akande accepted the offer, and in June of 2016, at the Holy Ghost service, he was allowed to perform for just 15 minutes and was also introduced as the writer of the song I Will Never Be Ungrateful. Like, imagine. Anyways, later on, Akande will find out that the general overseer, Pastor Enoch Adeboye, had given 10 million naira as a settlement sum of the copyright infringement claim, but he got nothing. Just a public acknowledgement that, he's the writer of the song, and then he got to perform for 15 minutes. I mean, come on. Should I say you're a pastor? I shouldn't be saying that, but yeah, you should expect, or we should expect better from a pastor, but then again, he's human, right? So yeah, I now did a poll asking, was the action by Pastor Ajayi not to give Mr. Akande the settlement money brought by the GO unfair, greedy, or a win-win? Now, 76.5 said greedy, and I agree. I mean, your GO will give you 10 million. Oh yeah, settle the author of that song, and you chose not to even give him, even if it's 2 or 5 million. I feel you can do better. While 11.8 said it's a win-win. How can that be a win-win, guys? Come on. Then I put I did put Thunder Fire the pastor, and nobody voted for that. I see we're a bit too religious, but other than he being very greedy, I don't know how to say this, but I'd rather not comment any further. Now imagine how Akande felt when he found out that he had been Now, imagine how Akande felt when he found out that the GO had actually given money for settlement. I mean, if I was the one, I'd be really, really, really upset. And that made him like take back his promise of, wanting to drop the copyright infringement case. So it's like, I'm not dropping the case again. I'm actually going to sue and pursue and get justice. So he will now write a letter to the GO narrating the recent activity, what has transpired, saying he had not received any settlement money and that he wanted the issue to be investigated, but he got no response, which is very typical. He wrote another one and still no response. Then he decided, or let me say, he remembered, oh, I have a lawyer. And then he's like, oh, do a letter and request that we should meet. I mean, I think as practitioners, we get to see this a lot, and it's more like a very bad habit our clients have. Like, when you're starting something, you don't remember that you need a legal practitioner. It's only when things get really bad or worse, then you're like, oh, lawyer, barrister, help me, like, come and save the day, Superman, yay. Anyways, the lawyer so 3 years later, Pastor Ajayi will again now reach out to Akande. So let's see, 2016. So in 2019, Pastor Ajayi now reaches out to Akande. And Akande has learned from what happened in 2016. Once beaten, twice shy. And he told Pastor Ajayi, please, you can talk to my lawyer. I don't want to have any conversation with you. So yeah, kudos, Akande. At least you finally stood up for yourself. So according to fig.ng, that is fig.ng, Akande is suing the RCCG for 350 million naira for infringing on his copyright. I will never be ungrateful. Please never be ungrateful in your life. But yeah, my thought is that this is a welcome development. I mean, kudos for setting this precedent. I hope that it goes, like, we get to have a precedent finally. I know when I put this up on my status on WhatsApp, I got a few comments, and one that stood out for me and I really resonated with was what Daphne said. Music is music. So whether or not it's a Christian or gospel song or a secular song, music is music, and music enjoy copyright protection, and it's listed as one of the works that enjoy automatic protection from the moment it's been created in a fixed medium. Now, other parts of a song would be sound recording and the composition. And then you must also show that sufficient effort has been put to make the work in question very original. See section 1 sub 1 paragraph A, B, E, and subsection 2 paragraph A to B. Copyright as an intellectual property is automatic upon creation, thereby allowing the author to earn a living by exploring and commercializing their economic right to make money, generate revenue. um Components of a musical work: the musical composition and sound recording. The relevant stakeholders and owners of a copyrighted work will include artists, musicians, songwriters, composers, record label, and the collecting society. Um, the rights that a copyright owner has are economic right to generate revenue through public performance, licensing of their song, also known as sync rights, and reproducing and distributing the song to the public, and also creating a merchandise, just like Burna Boy did for the Monster You Made song from his Twice as Tall album. Then you have the moral right or paternity right, which still gives the author the right to be named as the author of the work. So you still be acknowledged as the author of the work, and you also have a say as to how your work would be used. You also have a say as to the integrity of the work, meaning that it cannot be changed or mutilated or distorted without your express permission and input. And also, it cannot be transferred, unlike economic rights. See section 12 sub 1 of the Copyright Act. Other rights a copyright owner can enjoy include the right to reproduce the work, right to publish the work, right to perform it in public, right to distribute it to the public, and also make an adaptation. See section 6 sub 1. And this is specifically for literary, musical, and artistic works. While section 7 sub 1 paragraph A provides that copyright in a sound recording shall be the exclusive right to control in Nigeria, because IP, as we know, is territorial in nature. Now, paragraph A says the direct or indirect reproduction, broadcasting, or communication to the public of a whole or substantial part of the recording, either in its original form or in any form recognizably derived from the original. Then paragraph B states that the distribution to the public for commercial purposes of copies of the work by way of rental, lease, hire, loan, or similar arrangement. And that's on sound recording. So I asked the question, what if I was in the spirit, Lori Law, but I'm promoting the song Lori Raw? It's too stressful to clear the IP rights. Really, guys? Lori Raw. So I did another poll and I said, is a Christian or gospel artist a creative person? Thankfully, 93.8% said yes, while 6.3% said it's the Lord's work. I mean, you guys can be mischievous sometimes or naughty, but glad you guys answered that in the affirmative. Then I said gospel and Christian songs, like every other genre, has the business side of it, which is still like an untapped area in Nigeria. The importance of music to church service cannot be overemphasized. Now imagine attending church. So I'm Catholic, by the way. I know that there's a period during the Lenten season that you're not allowed to play any instrumental. Now picture this, imagine this, that you can't even do praise and worship, nothing. You just go to church, hear the pastor, put offering, and then you go back home. Like, how would the service be? 62.5% said empty, 37.5% said horrible. I mean, I do agree. Could be empty. You feel empty because you're more like you're not in the spirit. Like you don't have that ginger, Horrible. Yeah, I get. I really get. So one of the most important principles of intellectual property is that consent, permission, and authorization, CPA, is very important when you want to use or do an act that is exclusive to just an IP owner. Otherwise, your action will be considered to be an infringement, abuse, and total disregard for the author's work. C'est fini. Period. Does playing a gospel or Christian artist song or music, distributing the lyrics sheet or sheet music, displaying of visual photos and graphics, playing of online video clips, playing and streaming of movies, quoting of scriptures and written work fall under fair dealing as listed in the second schedule of the Copyright Act? The answer is no, it doesn't, because fair dealing basically means you're not using the person's work to make any commercial profit. You're not commercializing it. So the second schedule provides as follows: that the use will be considered to be fair dealing if it's for research purpose, if it's for private use, if it's for criticism, review, or used to report current events. If it's in public, it shall be accompanied by an acknowledgement of the title of the work and its authorship. So to explain this further, what that means is that from the moment the RCCG national team started to perform, they should have said, oh, this song was written and performed by Mr. Akande Emmanuel. This is not our original. So more like putting out a disclaimer out there. But I'm sure they've learned. So another way is that it can be done by way of a parody, a pastiche, or caricature, which was not the case here, as RCCG did not do any of the activities considered to be a fair dealing. Now, paragraph D reads that the reproduction and distribution of copies of any artistic work permanently situated in a place where it can be viewed by the public. And now when it comes to sound recording, remember I said a music is divided into sound recording and the music composition. Now, the third schedule of the Nigerian Copyright Act provides that copyright in a sound recording is not infringed by a person, which is referred to as a record producer, who makes a recording of the work or of an adaptation in Nigeria, if the record of the work, or as the case may be, of a similar adaptation of the work have previously been used in or imported into Nigeria for the purposes of retail sale, and were so made or imported by or with the license of the owner of the copyright of the work. So you see that even for sound recording, you still need a license if you're going to do any of those things. And also, before making the recording, the record producer has given the owner of the copyright the prescribed notice of his intention to make the sound recording, which RCCG National Praise Team never gave notice to Akande or his boss saying, oh, we want to use your sound recording, please give us permission. They didn't do any of that. And I've always stated how important CPA, as consent, permission, and authorization, is very important. Another thing we'll be looking at is the scope of copyright and related right, also known as performance or neighboring rights. Now, copyright protects literary, artistic, musical, cinematography works, sound recording, and broadcasting. See section 11 sub 1, where it listed the works eligible for copyright protection. While the performer and related rights can be found in section 26, which protects performing, recording, broadcasting live, reproduction in any material form, and adaptation. Then subsection 2 will list dramatic, musical performance, recitation, and reading of literary works as a performance. The term of duration, that means the number of years that it will enjoy protection, is for musical work is the life of the author plus 70 years after death, while for sound recording is the life of the author plus 50 years after the end of the year the recording was first made, while performance is the life of the author plus 50 years after the first performance took place. Copyright protects the author while performance right protects the performances, and consent must be sought before any recording, performance or broadcasting can even be made. On authorship and ownership, authorship in copyright rests on the person who created the work, while ownership applies to the person who merely contributed, say, informations or suggestions as to how the work should be created or expressed at the end of the day. Now, on infringement of a copyrighted work, see section 15, while for performance rights, see section 28 of the Copyright Act. Apologies, guys. And on remedies available for infringement of a performance right, see section 29, which states that the plaintiff shall be entitled to damages, injunction, account for profits or conversion, while section 16 sub 1 on remedies for copyrighted work lists damages, injunctions and accounts for the plaintiff. However, subsection 3 states that where the defendant claims to be unaware of the infringement, the plaintiff shall be entitled to any damages, but shall not be entitled to any damages, but an account of profit, whether or not any relief is granted. In wrapping up, where a dispute arises, parties can opt to either file a suit at the Federal High Court or even explore alternative dispute resolution mechanisms such as arbitration, mediation, negotiation, or even expert determination. Now, in light of the new normal, online dispute resolution mechanism can be explored where disputes can be heard, but parties would dispute can be heard virtually, but parties don't have to be physically present. So you just need to log in and do your hearing and move on. So how do Christians or gospel artists make money? Same way secular artists make their money, by exercising their exclusive right to perform in a church event, license it for church commercials and adverts, movies, publishing the song, and also understanding the business side of the industry that they actually belong to. Like, you guys just sit down like, okay, we need to do something about this right now. Take a vote, create a legal structure, have the right people that will, help make this process faster. Finally, in conclusion, talk with your intellectual property lawyer to know how to protect your creative content, especially if you're a gospel artist. You need to discuss with them and know whether or not the act committed falls under the fair dealing principle, and verify if there are laws within your jurisdiction or territory that permit certain aspects of copyrighted works to be used in a church. For instance, the United States Religious Service Exemption in the copyright law, section 110, sub 3, allows the works of a gospel artist to be performed freely or displayed in a worship service. Another option would be buy a blanket license that allows you to use the specific copyrighted work for certain purposes while the license is in effect. In the event of a dispute, you can always go to court or settle out of court. However, for this particular case, I would prefer and want it to be settled in court. So we have a precedent in relation to gospel songs and how the gospel industry should really do things in Nigeria. Next is, if you're organizing an event, get a license from the author or authors, giving you the permission. Get a license from the author or authorizing bodies, that is collecting society, to use the song and pay the royalties then get a legal opinion, just like how Nathaniel Bassey did for his Hallelujah Challenge. Consent, permission, and authorization is key for all forms of intellectual property. And so we've come to the end of today's IP series edition. Please, this is not a legal advice. If you need one, you can always talk to your IP lawyer or send me a message and let me know if you learned something new or if you have questions. And also tag me to posts or stories you want me to talk about onto the next IP series. Cheers, guys.